Michael Popak, Legal AF. Are social media companies responsible for the radicalization of serial killers and mass shooters who go on shooting sprees after being exposed to content on those platforms? That's the question that's up for grabs in a major case up in the upstate New York area in Erie County, where Buffalo sits, which is coming out of the 10 people who lost their life in a grocery store up in Buffalo, primarily Black Americans, at the hands of Peyton Gendron. Peyton Gendron, who was radicalized, the argument goes, and weaponized by watching on social media disinformation and racist hate content that was put forth and hosted and platformed on YouTube, Facebook, Reddit, and 4chan. Those entities all got together and moved to dismiss the lawsuit, arguing primarily two things, both of which were rejected by the Erie County Supreme Court judge. One, that they had a First Amendment right to allow all of this hate-spewing information, disinformation to be on their platform, even if it led to Peyton Gendron in one way becoming radicalized, picking up a gun and shooting Black people and driving hundreds of miles in order to do it. That's their first defense. The second defense, seeking the motion to dismiss, is that there is a body of law, there is a federal law particularly, which we call Section 230 of the Communications Act, which says that there is supposed to be some sort of civil liability defense or protection by content hosts, in this case the platforms, against being sued if they publish the content of others. In other words, they don't have an obligation to moderate. They don't have an obligation to take down hate and vitriol and racist attacks on people and letting it be exposed to somebody like Peyton Gendron under an interpretation of Section 230 of the Communications Act, which also contains a provision that says if they want to moderate, but without a requirement that they have to moderate, if they take down information, that they will not be subject to liability either under this Good Samaritan provision of Section 230. So all of these content hosts, all these platforms have tried to rely on Section 230. You've heard a lot about it, especially up at the United States Supreme Court, where they're going to be addressing a Section 230 issue. I don't know if it's this term or it's the next term, but here's the matter that's in front of the judge in Erie County and for which she just denied the motion to dismiss by these platforms. She said, you have an obligation because you profit from racist, anti-Semitic, and violent material, and that you encourage it. You promote it in order to have maximum engagement on your platforms, which brings you money. So you're craving grab for money at the expense, in this case, of Peyton Gendron's mind being intact is the reason that you should not be able to use Section 230 of the Communications Act as a defense, and certainly not the First Amendment. Instead, the judge adopted the arguments of the plaintiffs. There's 25 families of victims here who have joined together off the Buffalo shooting at the Tops Family Market, terribly named place for this tragedy, but it is what it is. They've all joined together, represented by a public interest law firm that focuses on gun violence, and the judge has adopted it. It's almost like a products liability analysis. In the products liability world, where you're suing as an injured party, you can say that a manufacturer of a product has put into the stream of commerce a defective product that ended up injuring somebody. So they used, from the world of products liability analysis, the lawyers here have structured the case, and the judge has bought into it, and I think rightly so, an argument that the platforms are defective. They are the product, and they are defective because they're not being properly moderated, and they're being used purposefully for profit as a clearinghouse for these not crazy ideas, not uncomfortable ideas, not unsavory ideas, downright dangerous, radicalizing, weaponizing ideas that goes beyond the First Amendment, right? It's like if you had a website that was devoted to, just teaching you how to shoot other human beings. I mean, that's effectively what the judge is saying. That it's sort of like The Purge, the movie, but in real life. that if you had I think we'd all agree, even Reddit, 4chan, Facebook, and others would agree that if they had on their platform a channel that was devoted to hunting human beings as the ultimate big game, right? And offering ways to arrange a human safari, I think that would be something that everybody would say you need to take down immediately. And if you don't, and somebody does this, you, the platform, is responsible. That is not that far of an extreme for what the judge is arguing and the plaintiff's counsel is arguing in this case. This one, not against Peyton Gendron, but against the people that weaponized him. What caused the defect? There's two things the judge analyzed. One, they have a financial motive to turn a blind eye to content moderation on their platform. And therefore, the platform is defective, and those defects are in a negligence analysis are the things that are causing the damage and the injury and the loss to the plaintiffs here, who are the families of the victims who died. 25, there were 10 people who died, and of course, there's 25 plaintiffs because, family members. I like a lot taking a page from the products liability world, which is very well developed body of law used throughout America to obtain redress and damages for victims of products that are defective. If you bought an electric saw, right, and it didn't have a safety guard and people were just losing fingers left and right, which happened in the past, that's a defective product, obviously. There's a feature of the car that's improperly designed or engineered or installed, and it leads to a wheel flying off at a high rate of speed at 70 miles an hour. You lose a wheel. That's a defective product. It's been put into the stream of commerce. You are liable and responsible for it. You pollute a waterway. You have runoff from a factory. Whatever you create requires chemicals, or you create chemicals. You manufacture chemicals, or you use chemicals in your manufacturing process, and then you dump them into a water stream, and downstream people end up having, babies with congenital birth defects, or born stillborn. That's a defective product, and that product liability analysis, which has been going on in America for 100 years or more, they then took that and overlaid it on a brand new technology, so let's say, of social media. Right? And brought it into the 21st century. And I think properly. I think that argument that they are a defective platform and they don't get to use the First Amendment to cover themselves, and certainly don't get to use Section 230 of the Communications Act, is genius. And I think the judge here has done exactly the right thing in the Supreme Court level, which, just for those that are kind of new to legal AF, that's not the highest court in New York. That is the equivalent of, in your town, what would usually be called the Superior Court. That is the trial level court. There's two levels of appeal above that. The highest court in New York of appeal is the Court of Appeals. Easy to remember. It's not the Supreme Court, because that name was already taken by the trial level courts. But the purpose of this hot take is to say that there's so much focus, and I wanted to kind of start doing these little tutorials, if you were on Legal AF, right here and on the MeidasTouch network, about the building blocks of these legal concepts. Because social media is being examined from a constitutional standpoint in 3 or 4 separate cases up at the United States Supreme Court. They just held oral argument about whether the Biden administration or any administration can lobby without coercive effect social media companies to take down this kind of disinformation, this kind of things that are getting people killed that are hosted on their platforms. So it's sort of the flip side of this particular lawsuit. And in that case, Murtha versus Missouri, the Supreme Court, from what we can see from the oral argument, led by Ketanji Brown Jackson, led by Kagan, led by even Kavanaugh, they believe that an administration should be able to be a participant in the public square and lobby without threatening social media companies, just like they do newspapers and media companies, to take down disinformation and write better stories. That's going to be allowed coming off of this term. This is the companion piece. When no one moderates, when no one lobbies, when no one tells them that they should take down human hunting channels, so to speak, Should those platforms be held liable? The answer is obviously, to me, yes. And that this judge in Erie County, New York, did the right thing in trying to find a way also to thread the needle so that that Section 230 federal liability insulation doesn't apply because of her defective platform analysis. There's other cases that are up for grabs. The United States Supreme Court also ruled just recently the NRA, of all things, because sometimes, of course, the Supreme Court can't choose who's going to be the party that's going to bring the case for the constitutional concept that they want to announce, that officials in government can't coerce businesses not to do business with other people, like the NRA. So a government official that doesn't like the NRA can't force other businesses not to do business with the NRA under threat of losing some other benefit or quality. That's a violation of the First Amendment, right? Government interfering with somebody's content-based viewpoint. We may not agree with the NRA, obviously, but they exist as a legitimate lobbying organization. And the government can't stop that from happening by interfering. Other Americans have their own First Amendment rights. That's different. So we have a lot of noise and a lot of heat, but not a lot of light yet around social media and the constitutional implications of it as the Supreme Court just wakes up and decides after 30 years of social media being around to address it. But cases like this are important. The next step on the train, I'm sure, is that 4chan, of all things, which is a QAnon-based platform, Reddit, Facebook, and YouTube are going to appeal to the appellate division for Erie County, which is the intermediary appellate court up there. My gut is they're going to lose there, and they're going to have to go to the Court of Appeals for the state of New York. There's no federal overlay here. I think they once tried to get the case out of state court to federal court. It didn't work. So they're going to be stuck after the next 2 rounds. We'll continue to follow. This case has been kicking around for over a year, but this is a brand new development, which I think is important to your understanding of the intersection of law and politics as it relates to principles of MAGA versus principles of the other party and how they get manifested in lawsuits and analysis like this one. We'll continue to follow stories at that intersection of law, politics, and justice. One place on the dial. You know it. You're right here now. It's the MeidasTouch Network. Help them get to 3 million free subscribers. And then follow me and my other co-leaders of Legal AF on Wednesdays and Saturdays on Legal AF, the podcast, where we curate the top 5 stories at the intersection of law and politics you need to know. We get behind the headlines, and we do it in one place. Wednesdays, Saturdays, 8 p.m. Eastern Time, this YouTube channel, and then on audio podcast platforms of your choice, Google, Spotify, Apple, whatever you like. If you like this kind of content, I'll keep doing it as long as you keep enjoying it. Let me know. Interact with the content. That helps with the algorithmic gods that control YouTube. Tell them you like the content, literally, by leaving a comment for me and a thumbs up. And then I've been known to sort of open the dialogue with you. We can have a little bit of a talk back. That's always fun. So until my next hot take, until my next Legal AF, this is Michael Popak reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.